Hello, and welcome to the Utah State Archives Government Records Access 101 course. I'm Monica Minaya, the Government Records Ombudsman, and I'll be taking you through today's online training. This course is designed to help give a general overview of GRAMA and the key roles and responsibilities of the Record Officer and Chief Administrative Officer. For a more in-depth training of GRAMA, please take the certification course that is available on Archives' website. Today I'll be going over 3 units: how to respond to record requests, how to classify records, and how to navigate the appeals process. At the end of this course, I'll go over resources that are available within the Transparency team and some tips on how to prepare for the State Records Committee. In this section, we'll be covering Part 1, General Provisions, and Part 2, Access to Records. What is GRAMA, and why is it important? GRAMA, Government Records Access and Management Act, is Utah's open record law. It was established in 1991 by the legislature. The intent of GRAMA has a basis of recognizing 2 constitutional rights: the public's right to access information concerning the public's business, and the right of privacy in relation to personal data gathered by governmental entities. GRAMA promotes the public's right to access unrestricted and public records, while providing guidelines for both disclosure and restrictions on access to government records. There are 2 key roles within the GRAMA process, the first being the appointed record officer, and the second being the Chief Administrative Officer. The Chief Administrative Officer duties are defined in Archives statute. The CAO establishes and maintains policy, procedures, functions, and proper documentation of the organization. The CAO can designate someone to answer GRAMA appeals and have them listed as a CAD, and we'll cover more of this in the appeals section. The record officer duties are listed in GRAMA, designated by the CAO as Archives point person for records management. They're responsible for maintenance of records and answering GRAMA requests. The appointed record officer needs to be certified annually, and that is available on the Archives website. Also on our website is the Record Officer Hub. That will contain everything you need in regards to maintaining and updating records for your agency. Please make sure to keep all of the roles updated, but especially the Record Officer and Chief Administrative Officer roles. This is important for our office to know who to contact and who we can refer the public to contact as well. How to respond to record requests. First, let's start with, is it a proper request? A person making a request shall submit in writing. Their request needs to contain their name, mailing address, email address if they're willing to accept email communication, a daytime phone number, and lastly, a description of records that identifies the record with reasonable specificity. Once you have verified that it is a written request, you'll acknowledge your receipt of the request and make sure to know a response if the requester is asking for their request to be expedited. Verify that it's a record that your agency has, or if not, notify the requester of that and who they should make the request to. Next is to identify responsive records. Determine whether or not it meets the criteria of a record. If you do not have the responsive records, were they destroyed due to your agency's retention schedule? And if so, make sure to make note of that when preparing your response to the requester. Once you have your responsive records, you'll move on to calculating the costs. Be sure to have an approved fee schedule for your agency. If the requester is asking for a fee waiver, be sure to address if you're granting or denying the fee waiver. You will also want to make note if the requester has listed a specific amount they're willing to pay. If the request is going over that amount, be sure to communicate that with the requester and get an understanding that they're willing to pay for the fee before you do the work. Keep in mind that you can request down payment if the amount exceeds $50. Classify the responsive records. Go over the responsive records and classify them. For any record that you are denying access to, whether the classification is private, protected, or controlled, be sure to note what the record is and give the citation. Please note to give the full citation and not just "it's private" under 302. And lastly, you'll plan your response. When you are responding to a requester, you are approving, denying, or notifying the requester. If you are using an extraordinary circumstance, be sure to make note of the date the requester will be receiving the records if known. Make sure to address all the items within the request in your response and include your CAO's information as well as the requester's right to appeal and the time frame that they will need to submit their appeal. Access to records, Section 201. These are just a few key highlights from 201. The public has a right to inspect a public record. A governmental entity is not required to create a record or compile, format, summarize, or tailor information. However, they may upon request. A governmental entity may not use the physical form, electronic or otherwise, in which the record is stored to deny or reasonably hinder the rights of a person to inspect and receive a copy of the record under this chapter. Section 201 also goes over the provisions of public, private, protected, and controlled records, disclosure and non-disclosure, certified copy of records, and the limits of obligations when fulfilling a records request. Response time. Section 204 will be your time frame section. It'll give you an outline of when you need to respond to a request and the provisions that will allow you more time when needed. After receiving a records request, the agency shall no later than 10 business days or 5 business days if the requester asks for it to be expedited, approve, deny, or notify the requester of an extraordinary circumstance. As I mentioned before, there are 9 extraordinary circumstances an agency may use to delay approval or denial by an additional time period. If the governmental agency fails to provide the records or issue a denial within the specified time frame, that failure is considered the equivalent of denying access to the record, and the requester may appeal to the CAO at that time. Denials. If you are denying access in whole or in part, you will need to supply the requester with the following information: a description of the records or the portion of the record which access was denied, citations as outlined in GRAMA, state statute, or federal statute if those apply, information that the requester has a right to appeal, your agency's chief administrative officer information, and the time frame they will need to submit their appeal, which is 30 calendar days from the date of the denial. Please note that unless ordered by the court, a governmental entity shall not destroy or give up custody of the record to which access was denied until the period for an appeal has expired or the end of the appeals process. This will also include the judicial appeal process. In this section, we'll be going over Part 3 of GRAMA, Classification. Duty to classify records. You are not required to classify a record until it is requested, but knowing your records well enough and having a records management plan that clarifies where records are and what citations to look for will help you as you answer GRAMA requests. Under Section 307, entities are required to evaluate their record series, designate each series, and report that to the archives. This can be updated at any time. Retention schedules have classifications on them, but when you get a request, remember, you need to look at each responsive record and determine what its classification is. one record can have more than one classification, and in those cases you'll redact what is not public and provide the rest. There are 4 classifications within GRAMA: public, private, controlled, and protected. Furthermore, GRAMA states that records are public unless expressly provided by statute. This means each request you get must be individually analyzed and carefully considered. A record can have more than one classification and require extensive redaction. Procedures for one entity might not translate well to another entity. Every entity has their own policies, and it's important to create your own framework and add to those policies as needed. We also like to note that it takes a lot of discretion to make these decisions on whether the requester is authorized to access the records. If you have any questions on if someone can have access to the records, please do not hesitate to contact the transparency team. Segregation. Don't forget to segregate. The primary tool for segregating records is to redact what cannot be provided by statute and release what is public. If a portion of the record isn't public but can be redacted or withheld somehow, so what is public can be provided, you can do that. And of course, the actual cost may be charged to the requester. As we've said, entities have the duty to designate and classify records. We'd like to take a moment to note that embarrassment and chilling effect is not a classification within GRAMA. Please make sure when you are giving denial reasons to only give the statutes as outlined in GRAMA or state or federal statutes. And how to find classifications. So for public records, there are 2 tiers. The first tier being must be disclosed but may contain confidential information. And the second tier is normally public unless otherwise stated. We'd also like to note that the list within public records is not exhaustive and should not be limited and should not be used to limit access to records. Private records. Private records are separated into 2 tiers as well. The first tier are statutes that are always private, and the second tier is private if properly classified by the governmental entity. Just to note, a few things that could go into Tier 1 are employment records, and an example for Tier 2 are other records containing data on individuals, the disclosure of which constitutes a clearly unwarranted invasion of personal privacy. And controlled records. Controlled records are records that contain medical and psychiatric or psychological data, and if released would be detrimental to the mental health or safety of the subject of the record. So the difference between private and controlled medical records is that the private records can be accessed by the subject of the record, where controlled records can only be given access as outlined in Section 202, subsection 2. And lastly, we have protected records. Protected records is everything else that is not public. The list grows every legislative session as records that have a strong public policy interest in non-disclosure and need to be specified in statute. Protected records include such things as trade secrets, jeopardizing the life or safety of an individual, attorney-client privilege, guarantee statements, and records concerning strategy about collective bargaining or imminent or pending litigation. In this section, we'll go over the appeal process and give information on the Ombudsman and State Records Committee. The appeal should have the requester's name, mailing address, daytime phone number, and a statement of relief they seek. If any of these are missing, it is an incomplete appeal. For incomplete appeals, we recommend good customer service by letting the requester know what they need to do to complete the appeal. A requester may appeal the denial of a fee waiver, records withheld, or redactions made due to classification, a claim of extraordinary circumstances, or they may appeal the lack of response from the record officer. An appeal may also be regarding a response that no records exist. However, this appeal must be supported by evidence that the entity does or should maintain the record. There are a few things that a chief administrative officer needs to do when reviewing an appeal. First, an appeal should be filed within 30 calendar days of a denial, and if not, it's untimely. It's important to know that the CAO has the same deadline to respond as a records request, so within 5 business days if the requester is asking for it to be expedited, or 10 business days. Under Section 401, subsection 5C, both parties can agree to extend the time period if needed. As I mentioned earlier, the CAO can designate someone to handle their GRAMA appeals on their behalf. That person again is listed as a CAD and should refer to themselves as a CAD when responding to a GRAMA appeal. When you have an appeal, the CAO needs to check if the appeal was correct. A few questions that you can do to ask to help with the appeal are, was a reasonable search done for the records? If not, you can order the record officer to do another search. Secondly, CAOs also can weigh public interests. For some designations in GRAMA, the CAO can exercise discretion to make an otherwise non-public record accessible. The interests favoring access are greater than or equal to the interest favoring restriction of access. You need to consider the public policies pertinent to the classification, disclosure, non-disclosure, and make sure other laws do not take precedence. If you have any questions about this part, you can reach out to the Government Records Ombudsman for help. If you deny the appeal, make sure to send a written notice of the decision affirming the denial. You'll also want to include that the requester has a right to appeal to the State Records Committee or District Court, and the time frame that they have to do so. Newly passed this year was that you are also required to include that the requester has a right to request mediation. Please also include the Government Records Ombudsman contact information within your denial. Now we're going to go into the State Records Committee. So there are 7 members on the committee: the State Archivist, 2 citizen members, a member of the media, a records manager from the private sector, a nominee from the Utah League of Cities and Towns, and someone with electronic records experience. A few timelines you should be aware of: our statement of facts are due no later than 5 business days before the hearing, and that you are required to send a copy of that to the requester by first-class mail. The Executive Secretary would like to note that the committee is made up of volunteers and none of them are lawyers, so brevity and plain language is always appreciated. 2 days before the hearing is the last day for the requester to ask to postpone. Current rules require the request to postpone to come from the petitioner, so we recommend working with the requester if you are unable to make the hearing. At the hearing, the committee may review the disputed records in camera. As a respondent, you are required to bring the records bank-stamped. The committee will vote on a motion at the meeting, so everyone will know if the appeal was granted or denied. The order is then drafted and sent to the parties 7 business days after the meeting. Parties have 30 days to comply with the order and file a notice of compliance or appeal to the district court. The biggest tip we can offer is to be prepared for your hearing. Often respondents are represented by an attorney, which is just fine, but make sure to meet with counsel before the hearing so they know about the records. It is also great to have the record officer at the meeting who can be called as a witness to answer the committee's questions about the records, how they are stored, and how the search was completed. So we'll go over the Ombudsman services. So I am able to mediate disputes, and also I'm a resource for the public and also for governmental entities in regards to GRAMA. We do want to emphasize that you can work with the Ombudsman at any point within the request or appeal process. When a requester files an appeal with the State Records Committee, the committee does expect parties to be willing to work with the Ombudsman in mediation to resolve as much of the appeal as possible. However, please note that your consent is needed to enter into mediation and can be withdrawn at any point within the process. If you have any questions about mediation, please contact the Ombudsman. So now I'm going to go into some resources that are available. So here is our transparency team. So we have the State Records Committee Executive Secretary, Rebecca Shaw, myself, Monica Minaya, the Government Records Ombudsman, and Dylan Mace, who's over the Public Notice website and the Open Records portal. Thank you for your time and attention throughout this training. Again, if you have any questions for us, please do not hesitate to contact us. We are here for you. Thank you.